Hey everybody, in this video, we're going to talk about some of the cases that have an impact on people, just in general. I want to show you some of the ways in which the court has interpreted the First Amendment and applied it to circumstances that may be familiar to you, or just really circumstances in the world. One of the foundational cases that I want you to be aware of is Tinker versus Des Moines. This is a really prominent case in establishing free speech rights for students. Now, I'm going to provide you with these slides so that you can read through the facts of these cases. But fundamentally, in a case like this, the question that came before the court was these students wanted to wear an armband in order to protest the Vietnam War. The school said, no, we're going to suspend you. They challenged it in court and said it was a violation of their First Amendment right to free speech. And the court said, yeah, you're absolutely right. And what this did is defined political speech as pure speech and schools, and it gave students the opportunity to express themselves in schools despite the administration's desire to silence them. So this is what established that students do not check their First Amendment rights at the door just because they get into a school. Now, not all of this is equally applied, though. So we had another case that kind of shapes this foundational law that we create in Tinker. Then we move on to a case like Bethel. Now, this was about a decade later, and Matthew Fraser also claimed political speech because he gave a speech in favor of a candidate for student body vice president. But you can see this is the speech here on the left-hand side. It wasn't exactly the same level of political speech that the Tinkers were aiming for. He gets suspended, he challenges it, and he says, I don't believe that the school can prevent me from giving this speech. I have a First Amendment right. And what the court said was, no, they can, that absolutely the school can prohibit the use of vulgar and offensive language and things that disrupt the academic process. This was not political speech just because it was for a student body position. It was a way to get attention and be disruptive, and so that can be prevented by the school without violating the First Amendment. Now, there's other school circumstances. This is a collegiate one where we had a police department in Palo Alto, which wanted to serve a warrant in order to have access to the Stanford Daily, which is the newspaper at Stanford University, because they wanted to get access to photos of protesters who had interacted with police, and they wanted to be able to search what then would have been dark rooms and things like that. So the Stanford Daily took this to court and said, did this search, because they, of course, ended up executing the search, violate the First and Fourth Amendments? The court said no, that there is no mandate that says that a newsroom cannot be searched. And when the when issues from police come up against issues of the press and the First Amendment, we need to weigh on a case-by-case basis whether or not the fruits of such a search would be necessary, and that there's no other way to get them. So this opened up the opportunity for the media to be susceptible to police searches. Looking back at schools, another case of significance that evolved, especially the public school First Amendment right to free press. This is considered a landmark decision that really shaped free press. This was in the late 1980s, where this newspaper in the Hazelwood School District was publishing articles about divorce and about teen pregnancy. And the principal said, no, we're not doing that. And he excised those pages from the publication. And Kathy Kuhlmeyer, who's pictured here, was one of the editors who brought this case to court, and she said, the question being, did the principal's deletion of these articles violate the students' First Amendment rights? And it would seem the clear answer would be yes, but in fact the court said no, and that schools have to be able to set this standard for school speech disseminated under their umbrella, and that they have the right to refuse to allow speech that's inconsistent with the kind of shared values that schools have. So this was a really landmark decision, and a chilling one, that said that administrations can censor student media. Another time and space when students can be censored. This is a pretty famous case that's best known as the Bong Hits for Jesus case, Morse versus Frederick. They held this banner outside when the Olympic torch was going by, and their teacher suspended them, saying that it violated the school's policy against promoting illegal drug use. And the challenge was, this is my free speech right, but actually the court once again said that school officials can prohibit students from displaying messages that promote illegal drug use or things that go against the moral code, and that although students do have the right to political speech, because we got that in Tinker, that doesn't extend to a pro-drug message. Now, of course, not all cases have to do with schools, and there's some other important cases that have come up. And I'm just going to give you a sampling of some of the First Amendment cases. Miller versus California. This has to do with the dissemination of material and how we identify obscenity. There's a pretty famous line back in the day before Miller that we used to identify obscenity because one of the justices would know it when he saw it. But what the Miller test did is this case established the Miller test, and it's this three-part test over here on the left that would determine whether or not something was obscene, because obscenity is one of only three categories of speech that are unprotected. So we have defamation is not protected speech, we have true threats, and also we have obscenity. Those are pretty much the only speech that is that does not have constitutional protection. And you can see the three things here all deal with whether or not something is sexy. So does it, applying contemporary standards, appeal to prurient interest, which means does it make you frisky? Does it describe sex in a patently offensive way? And does it not have any literary, artistic, political, or scientific value? We're going to talk a lot about kind of how those values come into play. And I want you to take note of the fact that there's nothing here that would represent language or violence that really would apply obscenity. So we're going to talk about that. Other cases that have come up, this was an attempt to regulate the internet and material that was considered to be unacceptable for children to see. The Communications Decency Act was going to criminalize the transmission of obscene or indecent material and information which depicts sexual or excretory activities in a manner deemed offensive, again, by community standards. That's pretty, that's a term you're going to see a lot. But the court prevented the government from enforcing this because it was deemed to be overly broad and it was vague in the definition of what types of communication it criminalized. And so it said that the act violated the First Amendment because it was basically a content-based blanket restriction of free speech. And that's one of the reasons why we see very little internet restriction now because of this case. Another case that's quite prominent, this has to do with whether or not we can have cameras in courtrooms, the Nebraska Press Association versus Stewart. This trial judge entered an order restricting members of the press from publishing or broadcasting. But the court, basically the media challenged that and said that they believe the judge's order violated the First and the 14th Amendment. And the court actually said yes, that they said that, implementing this kind of prior restraint on the press would not have served the accused rights. And we're going to see prior restraint come up quite a bit as one of the most grievous harms that can happen to the press. This is a case that identifies prior restraint and also identifies what a significant issue it can be when it comes to the government doing the people's business, and that one of those places that the government does the people's business in public is in court. Another very prominent case that comes out of the great state of Ohio is this one, where we had a leader of the Ku Klux Klan who made a speech. He was convicted under Ohio's criminal syndicalism law, which made it illegal to advocate a crime or sabotage or violence. But they Brandenburg challenged it and said that the law that prohibits speech basically was a First Amendment violation. It hindered his First and 14th Amendment rights. And the decision is that it did indeed violate the right to free speech. And so it established this two-part test to evaluate speech, that it can only be prohibited, as I mentioned to you, about directing and inciting or producing imminent lawless action. So that's one of those three areas of speech that's not protected. If it's an actual harm or likely to incite actual harm, but just getting up and saying hate speech or saying things that people find offensive is protected. And we're going to talk a lot about that this semester.